recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Holsinger, listening to the testimony and listening to the questions and responses, I want to get this back to what I think is the real problem. I understand there's a legitimate role for consent decrees and private suits, outside the public realm. And I understand there's at times legitimate role for them involving government. But I think we're currently in a situation where we're outside what would be acceptable. So my question is, do you believe that consent decrees that impose rules or do lawmaking and appropriate taxpayer funds outside of the elected government, Congress, state legislatures, county commissions, city councils, bless you, could deny people, we'll strike that from the record.
Don't strike that. I need that blessing.
Okay. Reclaiming my time. Let me restate this, that where lawmaking and appropriating is taking place outside of elected government, whether that's Congress, state legislatures, county commissions, city councils, that it could deny people their right to representative government.
Yes, thank you, Mr. Chairman. I agree wholeheartedly. In fact, a couple examples come to mind. We've been in the natural resources field in the West for a little over a decade now, and in that time we've been involved in about a dozen federal court cases, give or take. Several of those were cases brought by environmental groups in which we intervened to try to have a seat at the table in the litigation. And in many of those instances, the administration, in settlement negotiations with the plaintiff only, cut a deal to do something as a result of the litigation, which even we as litigants in the case had no knowledge of, no opportunity to participate in, let alone the public. And back to the example of the 2011 settlement with the U.S. Fish and Wildlife Service, that completely changed the direction of the agency, their priorities, and what they spent a huge amount of their time and resources on. So those are great examples of instances where sue and settle led to real regulatory impacts that the rest of us had no opportunity to participate in.
So the bottom line is, and I've seen this played out numerous times, is that you've got government agencies, whether at the federal, state, or local level, that are being run by attorneys and judges rather than mayors and governors and elected representatives. And, and I have a high regard for the folks that work at the Department of Justice, but with all due respect, Mr. Pideaux, they don't have legislative appropriated power. That's reserved to the elected representatives of the people. That's the big issue here. It's really not about regulations and environmental law. It's about who makes the law. It's about who enforces the law, who appropriates the money. The Department of Justice responsibility is to enforce the law. It's not to make law. It's not to enter into a private agreement with outside groups outside the legislative process. And I think what we're really focused on here is how do we restore representative government to the people at every level. That's a huge problem because, as I say, you've got these lawyers and judges, and some of these decrees have gone on for decades. And most of the people, they've gone on so long that the voters don't even know they exist. So I would like to ask you, Ms. Pideaux, would you support date certain sunset dates for consent decrees?
Can you repeat the question? Sorry, Chairman Palmer.
Do you support date certain sunset dates for consent decrees? That's a yes or no. Okay.
Yes, in some circumstances. I think it really depends on.
Why wouldn't you in any circumstance? If there's a specific remedy to achieve the objectives of the litigation, why couldn't we have a date certain? I mean, why would we, for instance, in a state, have a governor get elected office that inherits a consent decree with no opportunity whatsoever to get a remedy to that, so they get out from under that?
Well, Mr. Chairman, can I give you an example of where I would be uncomfortable with a date certain? I think maybe in contrast, it will illuminate my thoughts.
May I extend my time, Mr. Chairman?
Without objection.
Go ahead.
Give another minute.
So, for example, it was a consent decree entered against a reserve mining company in Minnesota dealing with discharge of asbestos into the waters of Lake Michigan, I believe. It was not a date certain consent decree because what was agreed to in the consent decree is that the company going into the future would never discharge asbestos in this particular way again. And so, in a
But
circumstance
that
like that,
that
adding a
doesn't mitigate against having a date certain for this, because the issue here is whether or not they're in compliance. If they're not in compliance, they're still outside the law, and our agencies have the ability to enforce that law. Let me ask you this. Do you support defining compliance language so specifically that it's clear that a decree requirement has been fulfilled? Because that would apply to your example.
I have not seen compliance language that is so specific in any settlement with the United States.
That's the problem.
I-
You don't define it, and it goes on and on and on, and the taxpayers are on the hook for it and don't even know it. I thank you for your indulgence, Mr. Chairman.
Thank you. We'll now recognize Ms. Dim.